Mr. Akitububo,
Yes,
before I read the decision of the court, the matter was initially adjourned because I will have given a bench ruling. But you said you were going to file a reply on point of law to the response of the respondent. And I discovered you didn't file any reply on point of law.
As the court pleases, my lord, we filed at the Akure
Where
registry.
did you file?
We filed long ago, sir. Immediately we left the court at Akure registry.
I found out from Akure, they said you didn't. In fact, I've spoken with Akure this morning also.
My lord, I actually filed.
Well, I didn't see any.
Because
of that, at the last sitting on 25th of March, the date the matter was fixed for the hearing, I called and they said you have not filed. When did you file?
My lord, unfortunately I'm not with the file now, but immediately, I even wrote a letter together with that process. Because my lord directed that we should write a letter that it should be adopted on our behalf, which we did.
Yes.
Yes, sir. We filed the process.
It means it wasn't filed before the 25th of March.
We respect my lord.
On that same day, I made a finding, Mr. Tolubabaleye.
We respect my lord. They actually filed after we have adopted. It was not filed within 7 days the court order. I expect my learned friend to tell the court about that.
No. It was filed within that particular day because, unfortunately, I'm not with my file now, sir. I'm sorry, sir. I'm sorry. This is a non-contentious issue. I can let it go, but I actually file within time. The court did order that we should file, and then we should write a letter pursuant to maybe order 10 of the practice of the Honorable Court, practice direction of the Honorable Court, that it should be adopted on our behalf. It was not adopted when we filed at all. Even sometimes ago, sir, Mr. Adam Paul called me whether we filed or not, and I told him that we filed.
I've even made the inquiry today as well. I've made inquiries because that's what I do when it has to do with interlocutory applications like this. I've called the registry in Akure to make certain inquiries, and they've responded to me. So,
my lord, I wouldn't know if the Honorable Court can indulge us, so that I will go to our registry and then find out what actually happens.
No.
So you want this application to be stayed again? No. I mean, you have said that this is an no-cause application.
Yes.
I mean, normally, like I said, I give a bench ruling regarding such applications. I don't allow it to, either I grant it or not. So that the other party, if I don't, then the other party may choose to go and seek for it in the appellate court. And if I did, then the matter goes on.
As the court pleases. My lord, we are leaving it at the discretion of the court.
Very well.
Most obliged.
Business Center.
Where is the ruling of the court?
As the court, please.
The judgment that two applicants filed a motion on notice on the 17th of July 2020, praying for an application. The order of this honorable court stay in execution of the judgment of this court delivered on the 4th of June 2020. In suit number NICS/AK/66/2018. The said application is premised on the grounds I have captured in this ruling. Supporting the application is an affidavit of 11 paragraph deposed by one Odunayo Iseye, an assistant director of administration in the third defendant applicant's establishment. Also filed in support is a written address. And I have reduced that also into the body of this ruling. Upon the service of this process on the judgment creditor responded, they filed the counter affidavit of 7 paragraph and the written address. I've reduced that equally into the body of the ruling. Now to my ruling. I've gone through the processes filed by either of the parties with the accompanying documents. The authorities relied upon to support their various positions. I've noted also that the issue formulated by both parties are on and the same, though phrased differently, and this court will adopt the issue formulated by the applicants. And that is, as evinced on his written address. The instant application, excuse me, is hinged on the judgment delivered by this court in Akure Division on the 4th of June 2020 in favor of the judgment creditors respondents, which is yet to be complied with as of today. In our application for stay of this nature, the applicant has the onus of proving special or exceptional circumstances to warrant the grant of same by the court, and these special circumstances have been enumerated in several cases by the court to include when execution will destroy the subject matter of the appeal, where it will force upon the court a situation of complete helplessness, or render nugatory any order or orders of the appeal court, where it will give rise to a situation where if the appellant succeed in the appeal, there could be no return to the status quo, and where the appeal has great merit, and that to enforce the judgment or order in the meantime will be ruinous to the applicant. See the case of Olunloyo and Adeniran citation is captured. I need to state here that in an application for stay of execution, the court has a duty to ensure that the successful litigant reaps the fruit of success in the case, while an applicant seeking to deprive a successful litigant of the fruit of his labor must show substantial reasons why the court must grant him such an indulgence. Going forward, the vital question now that need to be answered is whether the applicant has placed sufficient materials to show an exceptional circumstance to have this court exercise its discretion in its favor. Have perused the application and consider the argument of counsel in respect of same, as well as a copy of the application for leave to file appeal, and as the proposed notice of appeal. 13(2) A to B of the rules of this court 2017 provides for what need for stay of execution. Please mute yourself because I can hear some voices on the. Okay. Now the question is, has the applicant compiled a record of the court by paying the requisite fees? Has same been transmitted to the Court of Appeal for it to be seized of the appeal? Has the appeal been entered at the Court of Appeal? All these are the requirements and which are germane to the exercise of the court discretion. Rule 13 Rule 2, sub-rule 2, paragraph E makes specific reference to the order granting leave to appeal, which has not been obtained by the applicant in this instant. The applicant has argued vehemently that judgment creditor respondent in the event of a success of the appeal lacks the capacity and means to repay the judgment sum as they are employees of meager salaries. Respondent on their part contended that the applicant has not raised any recondite or substantial grounds in the depositions in the affidavit for this court to be persuaded in granting the application. I've carefully perused the processes in question in the light of the environment and legal argument in favor of each standpoint, and I find that all the requirements of law and the rules of this court remains unfulfilled by the applicant. Even if an appeal was already properly filed, the law is that it cannot operate as a stay of execution. See the case of Josiah Cornelius Limited versus Zinwa, citation is provided. I find herein, as stated earlier, that the applicant has failed to fulfill the precondition for grant of stay. The applicants herein pleaded in paragraph 7D that the appellate court has not assigned a date for the hearing of the motion seeking leave to appeal the said judgment. It is thus clear that no other step has been taken in respect of same. In essence, an appeal has not been entered in this case. It is equally clear on the face of the judgment and as established by the counter affidavit of the respondent that the respondent are in the employment of the third judgment debtor applicant. And as such, if they are paid their entitlements sought to be stayed, there is a way out for the judgment debtor applicant to recoup the judgment sum paid to them. I actually found out that what the judgment debtor, the grounds of the judgment debtor applicant is the award of a sum of 5 million naira as damages and nothing more. The respondent have a means of paying back the sum awarded as damages should the judgment fail on appeal. Flowing from the foregoing, I'm of a firm view that the applicant herein has not persuaded this court to exercise its discretionary powers in its favor. The application for stay of execution is hereby refused. Ruling is accordingly entered. So a copy of the ruling will be forwarded to each of your emails.
As a copy.
As the court pleases. We are most grateful for this well-considered ruling.
Very well.
Most obliged.
My Lord, we appreciate your lordship for this well-considered ruling.
Very well.
We pray for God's continuous strength for your land. I mean, for your landed court, my Lord.
Our local.
Abeni.